I want to touch real briefly on the idea of settlement costs. And we have gotten away from just talking about estate costs or estate taxes when we talk about estate planning. And in the area of non-traditional estates, I think the issue of estate settlement costs become even more important. Some estate costs are items that are solely to the individual that has died. Some can be continued by a surviving spouse or family member. But in the area of a non-traditional estate, we may not have, again, that designation of spouse that allows us to continue that on. So we like to talk about the idea of estate settlement costs, and we put together a real brief list of some of the ideas of what are contained in the idea of estate settlement costs. And these apply to almost every estate, but not every estate will have every one of these costs to it. This is where we can come in as planners and help provide the estate with a way to pay these types of costs, anywhere from the funeral expense and the medical expenses down to the estate and inheritance taxes. There may or may not be estate taxes, but I can almost guarantee you every estate will have some type of settlement cost. This slide is a marketing piece that we have, and it's available on SPA. That is something that you can present to a client, ask the client to give their best estimate of what these costs might be, and it gives you the ability to visit with them as to how those costs might be paid, and if insurance is a way to do it, do they have enough available at the time. Again, when we're talking about estate settlement costs and specifically estate taxes, the two best ways to avoid estate taxes is either to transfer your assets to a surviving spouse or to donate those assets to charity, because both of those escape federal estate taxations. Now, as we alluded to earlier, the same-sex couples don't qualify as a marital relationship under federal tax law, so that option may not be available to same-sex couples. It may be available in the instance of a second marriage, but do we want to leave everything to second spouse or third spouse if we have children from a prior marriage that may or may not inherit from that spouse? If we don't have a spousal relationship or a marital relationship, it's not possible to have an AB trust arrangement, which is typically setting up a spousal trust and a family trust. We would only have the ability from a tax advantage standpoint to set up a family trust under those arrangements. Still a very useful idea from a planning standpoint, but it might not be very helpful from a tax standpoint. And then when we're getting into the idea of settlement costs, the key to the whole thing is how do we pay for those costs? Do we use the liquid assets that are available? Do we have to sell illiquid assets? Do we have to borrow the funds? And finally, can we use life insurance to help pay those costs? Again, those are all ideas that are available. We'd like to help people out with that. Real quickly, I want to go through the area of gifting. A gift obviously can reduce the estate. Currently, that will reduce the estate settlement costs. But you can also, have the outright gift, or you can use a number of partial or future gifts, future interest gifts. The non-charitable giving is usually limited right now to $13,000 a year on the gift tax. Annual exclusion amount for 2009 requires a present interest gift, and we do have $1 million lifetime exemption should you exceed that amount. There's other more technical ideas in the gifting area, like qualified personal residence trust, grantor retained annuity trust, and all of the different initials that you see up above, intentionally defective grantor trusts, family limited partnerships, family limited companies, irrevocable life insurance trusts, and etc. We could do 2 days on just talking about these concepts by itself. So just keep in the back of your mind that these are ideas that are available in non-charitable gift planning. Charitable gifts, a great way to reduce the estate. During your lifetime, you have the ability to get an income tax deduction. It's removed from the estate, but you do lose control of the assets. Post-lifetime gifts or gifts after death occur. There's an estate tax deduction. Next slide. Estate tax deduction. There's no income tax deduction for these, but you do have the control of the asset during your lifetime. So for the right situation, you may have planning needs that include charities. Lastly, and real quickly, we'll talk about property ownership, where you have sole ownership or jointly with rights of survivorship, payable on death and transfer on death designations, which are very similar to beneficiary designations. They all avoid probate. They have the ability to transfer asset ownership very quickly and don't have to include it in the will document under jointly owned or payable on death or transfer on death designations. The last thing is beneficiary designations, which again pertain to a lot of the products we sell. It could include the asset in the estate, and the beneficiary designations will avoid probate and supersedes anything in the will. Again, it's very important to know what the provisions of the plan are so that your beneficiary designations can coordinate with that and not defeat the purpose of a lot of the other documents. We've got just a couple minutes left. I did want to touch on one of the products that we have that works very well in an estate planning situation, and that's our Guaranteed Universal Life Survivor product. It's our second. Provide for the estate settlement costs at their current spouse's death, but also provide for children from a prior marriage or from children from the current marriage. Our Survivor Life product is very useful also with same-sex couples in that we don't require that the two insureds be a husband it's opposite sex. You can have two of the same sex be insureds under our product. And again, this product is very useful in using with adopted children or children of a prior marriage if you want to make sure that they are taken care of, and also payment of liabilities at the surviving insured's death. That's what this product is all about. Real briefly, here are some of the product features of our Survivor Life product. Issue ages 18 to 85 with a minimum of $250,000. We have most of the same usual underwriting classes: preferred plus, non-tobacco, preferred non-tobacco, and we do allow a uninsured spouse combo as long as the healthy individual is at least a table 6. The max substandard combo is 16 and 8. If one of the insureds is greater than table 8, the other insured must be less. We have level death benefit option, guaranteed minimum interest rate of 3%. Loan interest rates you see listed on the screen doesn't become a really big issue in here because a lot of our products are sold to where the cash value is not subject to policy loans or not a part of that plan. And if it's inside of an irrevocable trust, the loan provision become relatively unimportant. We have a no-lapse guarantee of 20 years at least, a minimum premium no-lapse guarantee. We have a lifetime no-lapse guarantee to age 120, and we do have a surrender charge in the first 19 years. We have a term rider that helps in preserving the estate, and then we have a split option on a divorce situation that allows for the policy to be split into 2 separate policies. And we have an estate repeal provision that should the estate taxes be repealed, that the policy will waive all the surrender charges and the policy can be surrendered with no surrender charge of access. So with that, I think we are pretty much ready to go, and I'm going to turn it over back to Mikkel.
Thank you very much, and thank you everyone who attended today. We will be sending out a recorded version so that you can listen to this at a later date, forward it on to any of your friends. Again, Bob Burton is here in our office if you have any questions. Our phone number is 415-369-9990, and his extension is 116, or you can email him at bob@pravada.com. He'd be happy to answer any of your questions. So have a nice day, and thank you very much, Dave.
Thank you.